Despite those 8 fines, we have seen that the sector is improving massively. We've done a lot of real estate agents on-site visits. Even though we practically find some sort of breach or deficiency in most, the reality is that the more we visit them, the less we find that they have breaches and deficiencies. Most of them are very willing to cooperate, and this is noted by the OFT. Most of them want to learn, and we understand that they're also in an educational process, and they are getting better as time goes by. So we really try to support them, and things have to either go very, very badly wrong, or they don't heed what we're telling them in terms of improvement for us to take it to an enforcement stage. So it's not that we are actively looking to give them a fine or to have enforcement action taken against them, but we certainly expect them to react to anything that we discover is a deficiency or a breach.
So let's talk about those deficiencies and breaches. Could you give us some examples of the types of things you're seeing? What are the most common, for example?
We tend to find that their risk assessments, their money laundering, terrorist financing risk assessments can be very basic. They haven't taken into account all of the inherent risks that are applicable to their business. And as a result, because they haven't identified those risks, the CDD processes and the policies and procedures don't mitigate those identified risks. So essentially they haven't done the groundwork to create the policies which mitigate the risks that they should have identified. As a result, they are collecting CDD, customer due diligence, which is not the right one or the right level or identifying the right risks, and we therefore don't consider it to be sufficient for those purposes. We also find that less so now, but more before, they weren't meeting their Sanctions Act obligation by screening customers against sanctions lists, the UN sanctions list, the UK sanctions list, and the EU sanctions list. And we are also finding that they're not meeting their obligations in relation to the register of beneficial owners. So there's a whole raft of different items and aspects that we check during an on-site visit.
So in this particular case, which we've learned about today, the OFT has taken the decision to name the real estate agency in question. That's not something that they've always done. So what is the policy when it comes to naming?
Okay. I wouldn't want to discuss any particular agent at the moment. But generally, before the OFT takes a decision to make a publication, which we're entitled to and empowered to in legislation, there will always have to be an aggravating factor that leads to the decision by the OFT to publish the enforcement action taken. Now, normally that would be because a particular response from the agents hasn't been up to the standards that we expect, or because there have been breaches and deficiencies which are either significant or significant over a long period of time, and there is very little response from the real estate agents. So it's not something that we do lightly. We understand that naming an agent has a big detrimental effect to that business in such a small community, but nevertheless that's part of the point of publicizing the names. It's to send the message to other agents that they need to take the AML-CFT obligation seriously, that the OFT as a supervisory authority under the Proceeds of Crime Act has a serious role to play, and that agents need to collaborate with us in order to avoid those sanctions, and in order to avoid those sanctions becoming published if we don't see that they are taking responsibility for improving the way that they are meeting those obligations.